This is David Howard for Vader TV. I'm here with Dana Schultz today. Dana is an attorney who serves primarily small startup companies focused on technology. Thank you for talking to us today, Dana.
Thank you, Dave.
So, Dana, you've written this article, Top 10 Mistakes That Small Companies Often Make, and one of the things you lead off in that article with is when you're working with employees or working with contractors and they do work for you, there's oftentimes questions about who owns the work product. Can you tell us more about that?
I sure can, Dave. It probably shouldn't astonish me, but it does astonish me how unclear some entrepreneurs are on this issue. Very frequently they believe, put simply, if I paid for it, I own it. Regrettably, that's not always true. Let's start first in the context of independent contractors doing work for a company. Because small startups often, to keep their expenses as low as possible, will engage a lot of independent contractors rather than employees for the company. We'll talk a little bit later about different types of intellectual property, but depending on what type of intellectual property might be appropriate for protecting that work product, the law is probably going to tell the company that it doesn't own that work product and thus its intellectual property until and unless there is an agreement between the independent contractor and the company that says the independent contractor assigns that work product and all rights over to the company. So let me give an example. In the realm of copyright law, copyright protects works of authorship. Let's say you had some software created for you by an independent contractor. Under copyright law, that software and its copyright is owned by the independent contractor. What that means is that you, as the company who retained that independent contractor, probably will only have some sort of license to that software, and a fairly limited one at that, meaning that if you built your company with the idea that you would own that software, you are going to be very severely disappointed. Similarly, let's talk about patents for a second. Patents protect useful inventions. If you had work product created, it was a useful invention, you were building your company and expecting to get financing for it based on having the patent rights to that particular invention, you could again find yourself very disappointed because you would not have those rights, and your entire business model could fall apart at that point.
So I think you kind of spoke to this. Even if you have employees, not just contractors, but even employees that you come on a W-2, you still want to get that kind of invention and work product agreement in place. Is that right? That's
true. You're certainly, as the employer, with a better off starting point with the employee. Because again, as an example, under copyright law, if an employee rather than an independent contractor creates that piece of software for you, then you as the employer are going to own the copyright to it. With patents, on the other hand, it's not quite so clear-cut. It will depend on the circumstances. You may own the patent, or the employee as the inventor may own the patent. So it absolutely makes sense both in the independent contractor situation and in the employee situation to ensure that you have an agreement in place that assigns to the company all of the rights to whatever work product is created. Okay, and you promised to tell us some more about other types of intellectual property. Obviously, patents come up first and foremost. People focus on that a lot, but there's more to it beyond that. What else is there? Patents and copyrights and... You're right again, Dave, yes. So to recap, patents protect inventions. If you have a patent on an invention, you can preclude other people from creating that invention, from using that invention, from selling that invention, from offering that invention for sale. Copyright protects works of authorship, whether it's software or songs or books or anything you write, or even pictures that are created, graphic designs, artwork, etc. Copyright is what protects those. The third is trademarks and service marks. These are marks that are assigned to products that are associated with the provider of those products that help people to understand and be sure about where that particular product or service came from. So one of the names, for example, is Xerox. And they spend years in many advertisements making it clear that Xerox is their trademark that's applied to the name of a product that they provide. And then the fourth type of intellectual property that we look at is trade secrets. Trade secrets are information that's not generally available to the public, that gives your company a competitive edge in the marketplace, and that you use reasonable effort to maintain the secrecy of, that is, to protect. And so trade secrets are a major reason why, for example, non-disclosure agreements, NDAs, are so prevalent, especially in the technology world, because companies want to make sure that before they reveal information to a third party, there are confidentiality obligations in place so that they can protect the trade secrets of that information.
Dana, this is great information, and I appreciate you taking the time to talk to us today and tell us about this.
Thank you, Dave. My pleasure.
Thank you.